Hello and welcome. Now, the politics in Kano State has assumed a new dimension after the Court of Appeal sitting in Abuja affirmed the tribunal's judgment, which declared the All Progressives Congress candidate Nasiru Gawuna winner of the governorship election. The tribunal, led by Justice Oluyemi Osadebe, nullified the election of Governor Abba Yusuf of the New Nigeria People's Party (NPP) by declaring 165,663 of his votes invalid, and held that the ballot papers were not signed nor stamped by the Independent National Electoral Commission (INEC). Now, delivering judgment on the matter on Friday now, the appeal court held that Yusuf was not even qualified to contest the election in the first place because his name was not in the register of his political party. In a similar development now, the Court of Appeal in Abuja of course, voided the election of Dauda Lawal as governor of Zamfara State. All three panel members now of the court, led by Justice Omoloye Jumbo Ojo, on Thursday ordered a rerun of the election in three local government areas of Birnin Magaji, Bukuyum, and Maradun. In the lead judgment delivered by Justice Sibyl Bagi, the appellate court faulted the Independent National Electoral Commission (INEC's) use of IREF for the collation of results when the Supreme Court had ruled that it is not a result collation system but only for public viewing. The panel unanimously held 4 out of the 7 issues for the determination in the appeal brought by the All Progressives Congress candidate in the election, Bello Matawali. Now, joining me to discuss all of this issue is Libros Oshoma, who is a political affairs analyst. Libros, let's start with the appeal court decision now. The appeal court's decision on the governorship of Kano State. Give me your take on it. And the reason why this is curious for me is because, look, before now, this is a similar issue actually came up at the Supreme Court and even at the presidential election petition court now. I mean, the issue of whether the Labour Party candidate was a member of his party. And of course, you know how the Supreme Court and even the Court of the Presidential Election Petition Tribunal now ruled on that issue. But here we have a situation where the appeal court is now saying that Governor Abba Yusuf was not a registered member of the NNPP even before the election. How do you explain this?
Yeah, Deji, since from the time I heard that pronouncement, I was taken aback because there was the concurrent judgment of the Court of Appeal and that of the Supreme Court in the presidential election petition that the issue of party membership is a pre-election matter, and not just a pre-election matter, that it is a determinant only by the political party, and it was not meant for adjudication by members who are not members of that political party. That was the position of the Court of Appeal sitting at the Court of First Instance in the presidential election petition. And then also was the same position of the Supreme Court. That issues of, and on that note, it was on that note that the Court of Appeal in Undudi Elumelu's case in Delta North, in the House of Rep matter, mind you, the tribunal had heard, following that position, that the Labour Party candidate in that election's name was not on the register. So it was on the pronouncement of the presidential election petition tribunal, the Court of Appeal sitting as the Court of First Instance. It was on that pronouncement that the Court of Appeal, in this case, nullified or dismissed the, allowed the appeal brought by the Labour Party candidate that membership is a purely political party affair and also that is a pre-election matter. So I'm also taken aback now that the Court of Coordinate Jurisdiction, a concurrent court, or if you like, let's say a Court of Appeal is going against the decision of a Supreme Court, where the Supreme Court had held that Obi's name not being on the register of member is qualified to conduct election. So I wonder why the Court of Appeal will go back and disagree with the Superior Court judgment that his name not being on the register of member, to that extent, he was not qualified to stand for election in Kano State. Also, remember that issue came up in Lagos State, the Labour Party candidate in Lagos, I think Vivor, because as at the time he contested also, you know, a lot of them were not members of Labour. They just hopped into Labour when they were denied the ticket in their various political parties. So, and the Supreme Court had put a finality to that it wasn't a matter for debate at the Election Petition Tribunal. So I wonder what the Election Petition, the Court of Appeal would want to achieve with such a judgment on this matter. But the good part of it is that the matter ends at the Supreme Court. Okay. And so the Supreme Court will still have a say, a bite on the matter. So we want to see if the Supreme Court will go against its earlier judgment on the matter, or it will, you know, simply refer the tribunal back to its judgment and hold that the issue of membership of political party, you know, is not debatable at the election. It's not litigatable at the Election Petition Tribunal.
Now, let's look at that of Plateau State. That's another one that is generating a lot of controversy. I'm very sure you followed that case and you're aware of the way the appeal court ruled on that. In this case, the PDP, of course, there was a court judgment that required the PDP to conduct primaries to elect its executive in that state. The PDP did not do that. This case went up to the Supreme Court and the PDP lost the case. But in any case, the PDP still went ahead to sponsor candidates for the election. But then the appeal court now are saying that, look, that by acting the way it did, that it's deemed, by refusing to obey the court order now, it's deemed that the PDP did not sponsor any candidate at all in the election because there was no structure in the states as pronounced by the court. But then some people are arguing now that, well, since the Supreme Court has said, you know, that pre-election matters should not count at all in resolving election petitions. And so that the court should just have turned a blind eye to that court judgment that required that the PDP, that ordered the PDP to conduct a state congress now to elect state executive. I don't know. What do you make of that? Could we say the issue of pre-election matter not pre-election matter now not coming or not interfering now with election matters properly? Could we say that principle applies?
Edeji, the issue of Kano State is different from that of Plateau.
Yes, of course, different.
State is simply a repeat of what played out in Rivers State in 2019.
And Zamfara State.
If you remember, yes, and Zamfara State. If you remember in 2019 in Rivers State, the Congress that were held by the Rivers State PDP, APC, were nullified by the court. And the matter went as far as the Supreme Court. And the Supreme Court held that since there was a subsisting court order requesting them not to conduct primaries until the determination of the issues raised in court, and that any subsequent primaries that was conducted was a nullity. And since the primaries, since the Congress that the Congress subsequently conducted was a nullity, and that the court, you cannot put something on nothing and expect it to stand. So to that extent, every action taken by that Congress, that any action that arose from the outcome of that Congress will certainly amount to a nullity. So that's basically what is playing out in Rivers State.
In Plateau State, you mean?
When the court...
In Plateau State?
In Plateau State. When the court heard that an action should be carried out or an act should be done in a certain way, and that act is not done, and the court now heard that for not complying with that instruction, what it means is that there was no Congress, and since there was no Congress, there can be no elected officials of the political party. And if there are no elected officials of the political party, how do you now say that the political party actually, or those people who pretended to be elected officials, took decisions for and on behalf of the party? That one was what played out in Rivers State against APC in 2019 and against the APC also in Zamfara in 2019. Unfortunately, that is what is facing PDP today in Plateau. So it is completely, this is not a pre-election matter per se. It is the fact that there is a subsisting judgment that orders parties, for example, to go and conduct a Congress. And so in the absence of that Congress, any step taken will not be recognized by the law. So it is not a pre-election matter. Just the same way the Supreme Court, in the case of double nomination for the current vice president, the Supreme Court said we had dealt with this matter. All of the issues raised, we have dealt with, and we have looked at, we have even gone into the midst of the gravamen of the issues and determined that there was no double nomination. So raising the issue again at the Supreme Court was akin to flogging an issue that had been ruled on. So in this case, that the court is saying that there is an order by the court that parties should follow a certain provision. And in the absence of that provision, there is, what it means is that there is no political party. And so when there is no political party, you cannot be feeding candidate. That's basically what the case of Plateau is.
All right.
Unlike the case of Kano. The case of Kano is that there is a political party. However, once the political party determines that this is their candidate, it is not for the court to begin to say, because your name is not on the register, that you cannot be a candidate in the party. That was what the Supreme Court decided, that the court had decided to pick candidate, the party had decided to pick its own candidate. And they went through the processes of Congress to elect officials and all of that, primaries. Once they've done that, it is not for somebody who is not a party to the primaries or who is not a member of the party to begin to question the validity of that candidature. That was the position of the Supreme Court. I wonder why the Court of Appeal is going against it now in the case of Kano. And then quickly, Deji,
yes.
I must say this, that the court also should be very careful in the way they handle this decision. They should refuse to be influenced by any party because the fallout of the election is still very fragile. People are gradually losing hope and trust in the judicial process. And there's this tendency, this belief that, some unseen hands are manipulating the judiciary to give some decisions.
Now, Libros, just hold it. Just hold it there.
Let me land on this.
No, okay.
Sorry. You know why? Because it is for conflicting decisions like this. Remember, before now, governorship election petition terminates at the Court of Appeal. It is for conflicting decisions like this that the Supreme Court, in its wisdom, decided that all election petitions should terminate at the Supreme Court so that there be uniformity. So a situation where the Court of Appeal is clearly going against the Supreme Court, definitely you allow mischief maker to read meanings into it. That's basically what I want to say.
We're still going to talk about this issue of conflicting judgment now, but let's just quickly take a short break. I'll come back and we'll continue the discussion on this very interesting topic, I must say. So we'll take a short break and we'll be right back. Welcome back. If you've just joined us, we're looking at election petitions and, of course, rulings of courts and courts of appeal on the 2023 general elections. And I have Libros Oshoma, who is a legal practitioner. Now, Libros, thank you very much for your time. Now, you talked about courts now issuing conflicting judgment. And let's go back to this Plateau case, because it's one that I'm really confused about, and a lot of our audience too are confused. There have been a series of protests in Plateau State because people don't really understand. Now, in the case of the governor, when the petition of the governor was brought before the state, that's the Plateau State Election Petition Tribunal, that tribunal, the issue of the governor's qualification, whether PDP should have fielded the governor as a candidate, that issue came up. And that tribunal ruled in favor of the governor, saying that it was pre-election matter. The same tribunal, when the case of lawmakers in the state was brought before it, ruled otherwise, to say that, look, the PDP should not have fielded candidates because there was a judgment against the Congress that the party organized, that the Congress was not properly organized. And of course, you know, when the case got to the Court of Appeal upheld that. But we're still waiting, of course, for the Court of Appeal, of course, will still have to decide on the case of the governor. But I'm just wondering, at that election petition tribunal, why would the election petition tribunal now give conflicting judgment now on two similar cases?
DG, that's why I am saying that the courts, tribunals inclusive, should be very careful. You remember the case of Zamfara? Not a single candidate was standing in Zamfara. All of the candidates, from the governor to the House of Rep, to the Senate, to the House of Assembly, that the Congress produced, all of them, by one full swap and one judgment, were asked to vacate their seat. So in the same vein, but even though that subsequent judgment did not come from the election petition, it came from the Supreme Court that determined eventually, you remember the Marafa faction and Yaris faction.
Yaris faction, yeah.
It came as a result of the determination by the Supreme Court that the Congress conducted by the Abdulaziz Yaris faction was not properly conducted and was outside of the time required by INEC, the timetable issued by INEC. And that so, since it didn't meet the provisions of the law as issued by INEC, and that there was no candidate. But in this current case, all of the issues had been decided by the Supreme Court that the Congress were not validly conducted. All the tribunal ought to have done is to take cognizance, judicial notice of that Supreme Court judgment. And also, there will be no exception. There ought to have been no exception.
But in this,
whether the governor,
you're right, but in this case, the tribunal took judicial notice in one case and did not take in the other.
That is why I'm saying that the tribunal, the election petition tribunal, should not act in a way that it will look as if there are unseen hands that are beating the drums for it. Because the impression would be that the court can be manipulated to give, you know, in the same set of facts, give decision to A, favorable decision to A, and give unfavorable decision to B, examining the same set of facts, because it is the same Congress that produced both the governor and the members of the House of Assembly that we are talking about. So you cannot recognize in one breath, recognize that Congress that has been held to be ultra-biased, the powers by the Supreme Court for the governor, and then in the other cases, you now say that you do not recognize that Congress. So that's why, for me, I think the court should be very careful. And I also would think that the Court of Appeal or the Supreme Court subsequently will correct all of this in the case of the governor, because also I think he's still sitting on the keg of gunpowder. And this is why people, the judiciary will consistently be on trial. Like Lord Denny once said, when a judge sits on trial, the court is on trial. Because when you're trying one matter, the politicians know the truth, but it is the judge that is on trial. That's what the judges don't know. They are the ones on trial. They are the ones that the public will call. They are the ones that the people, they are the ones that we are discussing here now, and not the politicians. So the judges should be above board, irrespective of the lures or attempt by politicians to compromise them. They should ensure that the consistency becomes the hallmark of their judicial aim. Otherwise, we'll gradually use some of these judgments to destroy that credo of the judiciary that we once all reverenced.
Liberal Sushuma, I think we'll just have to leave it there. Thank you so very much for your time, and thank you for your contributions.
Always my pleasure, David. Always.
Thank you. Well, that's it on the program this week. Thank you very much for watching. I'll see you again next time. Bye-bye.